Hello, welcome in the Erasmus plus CHAISE project, Module 2, Regulation, Legal Aspects and Governance of Blockchain Systems. In this fourth lecture, we focus on the blockchain regulation, identifying blockchain actors and the way their interaction with their environment is legally controlled. This lecture takes advantage of the knowledge and skills provided in the previous lectures, with the blockchain context defined in Lecture 1, the governance background defined in Lecture 2, and the organization of the blockchain ecosystem proposed in Lecture 3. Attending with this lecture will provide you few skills, such as describing blockchain-related legal environment in Europe and the world. You can also explain regulatory frameworks of blockchain based on financial services, and you will also be able to recognize legal and regulatory issues and risks when dealing with cryptocurrency and blockchain technology. This will also make you be capable of practicing critical thinking of the blockchain legal environment and regulation and take responsibility when deciding about the blockchain, cryptocurrencies, and use of smart contracts. These skills are based on basic knowledge about the blockchain-related legal environment, the legal underpinnings of blockchain technology and of smart contracts, the legal implications of cryptocurrencies, and blockchain and public policy versus governmental regulations. Identifying blockchain regulation principles or existing legal frameworks involves identifying the regulation scope. Should blockchain regulation be focused on technology or on blockchain deployment and blockchain usages? To define the regulation parameter, we have first to identify regulation motivations and the main requirements. As a technological object, blockchain systems are deployed on the Internet. Should regulation depend on existing borders, or is there any worldwide regulation? Are there specific requirements related to the blockchain systems, or can blockchain regulation be derived from other regulations? Are there some usage-dependent regulations? Why? All with these questions, and the answers are not so simple. Let's think and brainstorm regarding these questions. According to your best knowledge, is there any Internet regulation? Who define common rules on the Internet? States? Companies? The Internet? Nobody? Are distributed systems, such as Internet-based systems, totally free and independent? Could it be possible that a state tries to regulate activity on the Internet? Do you know if such thing happened? When? What was the context? Why? Do you know if some technological fields are regulated? Is it regulated depending on the technology or depending on its application? Let's say on the business activity. May regulation apply in physical or in virtual worlds? How can we define borders in virtual worlds? Are some regulations depending on usages of technology? As you can notice, describing blockchain regulation requirements and challenges is not so simple. This requires identifying key regulation principles, understanding why and how regulations are set, understanding the regulation context, the business activity, the motivations, and so on. This lecture is designed to provide the necessary knowledge to understand and discuss key regulation principles and blockchain regulation requirements. To understand and discuss the way regulation mechanisms are applied to the blockchain context, you will be introduced to the virtual asset protection context before learning the way applicable regulation mechanisms are applied to blockchain usages. To sum up, this lecture addresses different learning objectives, the regulation context, the blockchain key regulation principles, and the virtual assets regulation. Focusing on the blockchain context, you will learn the basic regulation motivations by identifying what needs to be regulated, either the core technology or the usages relying on this technology. This will guide the identification of the key blockchain regulation challenges. Based on these motivations and challenges for blockchain regulation, you will learn how regulations incentives are set to support blockchain development. You will also learn about key technical regulation principles such as blockchain legal status and the way it has been designed, the smart contract status, and so on. These are key blockchain regulation principles. As blockchain 1.0 is mostly associated to fintech and virtual assets, we will pay particular attention on the way regulation impacts the token status and the way fiat currencies are legally defined. Lastly, considering blockchain as a support for virtual assets development, you will be introduced to virtual asset regulation motivations, mostly to face specific risks. You will also get knowledge on the international regulation implementing the proposition of the Financial Action Task Force, which is an intergovernmental organization founded in the late 80s by the G7. This organization is in charge of proposing policies to control money laundering and terrorism financing. It deals mostly with transfer of fund regulation and the market in crypto asset regulation. According to the learning objectives, this lecture is organized into three main parts. We will first introduce the regulation context, introducing technology regulation challenges, and detailing key blockchain regulation challenges based on blockchain typology. Based on these regulation motivations and requirements, we expose then the blockchain key regulation principles. This part will introduce the main blockchain incentives and the blockchain legal status, before focusing on token status and fiat currencies regulation key principles. As the blockchain is largely used to support fintech and cryptocurrency development, the last part of the lecture will present regulation, motivation, and key risks associated to these virtual assets, before introducing regulations derived from the Financial Active Task Force, an intergovernmental organization in charge of fighting money laundering and terrorism financing. First of all, let's come back to basics, defining precisely what regulation means. As introduced in previous lectures, regulation controls the interactions of an ecosystem with its environment. Regulation is defined, according to Cambridge or Collins dictionaries, as an official rule or act, or as the action of checking whether a business follows or not the official laws or social rules. Focusing on the regulation rules, acts, laws, and even social rules are defined by authorities, either governments or other recognized authorities. Their design follows specific validation processes before being submitted formally for approval. Once approved, these acts or laws are promulgated. We can note that laws can be either primary or secondary laws. A secondary law amends an existing law. It may add rules or it may precise law application context and rules. In other words, the secondary law derives and amends rules from the primary law. And in an evolving context, it means that the primary law provides the global scope and the secondary laws are used to precise it, according to various contexts. As regulation laws and acts are defined by each country, it means that rules may be different from one country to another. This leads to key questions to identify which laws are applicable and which court has jurisdiction. It involves that laws must include territoriality or extraterritoriality explicit conditions. Low territoriality means that the law is applicable depending on the physical place where the actions take place. Low extraterritoriality means that the jurisdiction of a country can be competent according to some conditions, even if the action does not occur physically in the country. For example, GDPR provides an extraterritorial personal data protection for European Union citizens. Focusing on business regulation, common worldwide rules are defined. First of all, business interactions are supported by contracts. Contracts gather a description of the business interaction, applicable rules. Contracts are written in the style of law, and they contain several articles. They usually follow a same template to set the different party identification, the business purpose, applicable business rules, and applicable legal environment. Parties' precise identification includes the party verified identity, its role and its responsibility, and we have to define also the way to refer to a particular party in the contract. We will have also to fix who will represent this party to approve the contract and who will sign for the contract. The business purpose provides the exact definition of what will be done or provided by which party to achieve a precise goal. The applicable business rules are related to extra requirements, including time validity, time constraints. There may be some rules related to the quality, such as quality measures, responsibility. We have also rules dedicated for pricing for each party. To sum up, contract execution conditions, who will be responsible of what, and so on. Focusing on the legal environment, the contract has also to set the competent jurisdiction accepted by all parties in case of troubles. It means that all parties accept that the applicable laws are the ones from the country of the accepted jurisdiction, even if the action takes place in other countries. Contracts must be approved by all parties, who have to sign them to authenticate them. Several copies of a contract are signed, so that each party has its own originally certified copy of the approved contract. A party can use its own copy to prove that the contract has been approved. Blockchain technology can be integrated in this contract approval process. By providing a trusted certification and a trusted storage, contracts can be stored immutably in the blockchain. Nevertheless, as blockchain supports only peer-to-peer transactions, a dedicated approval process must be set to support the automated signature process. Moreover, depending on the type of blockchain, permission or permissionless, a particular attention must be paid on confidentiality constraints. Contracts must be encrypted so that they cannot be read by unauthorized parties, and trade secrets are protected. When blockchain is used to support business development and interactions between parties, a particular attention must be paid on the type of blockchain. Should it be a public blockchain, which is ready to use and require reduced investment? Or should you define a consortium or private blockchain, which require more investments and more time to be deployed? Depending on the type of blockchain and of its ecosystem, there are different legal frameworks that may apply, and this will also impact the business regulation. What we just said means that technology or its usage may impact business regulation. As a consequence, technology or its usage needs to fulfill regulation rules. In fact, technology can be considered as an inert passive object. Its implementation allows using it, and the way it interacts with its environment depends on the usage. So it is rather the way the technology is developed, implemented, and used that requires regulation, and not technology by itself. Technology, its design and its usage must comply their legal environment. This legal compliance requirement covers core development, so developing a technology means that you must comply ethic, economic, environmental, security, business, regulation. Legal compliance requirements must also be taken into account for usage development, as implementing and using the new technology may have social, economic, and environmental impacts. To sum up, technology is regulated to ensure that its impact complies with the law. As technology can be used worldwide, regulation territoriality must be considered. In fact, different usages can be allowed or forbidden depending on countries. As far as tangible technologic objects are considered, identifying the convenient legal framework depends on the place the object is physically located and used. For non-tangible technologic objects, there is no worldwide regulation. A particular attention must be paid on the usage location, on the location of the technology owner, and where the usage support system is physically located. As an innovative technology, we have to evaluate requirements for the blockchain, paying attention to the way the technology is designed and implemented, as well as requirements associated to the usage, socio-economic context, and the technology impact. Focusing on the technologic side, blockchain provides a trusted peer-to-peer transaction support. The secured immutable storage of transactions into blocks proves that the transaction occurs. It means that peers delegate the double spending problem proof to the blockchain. The integration of blocks and tokens history on-chain allows developing ad hoc backtracking processes to fit legal tracking requirements. Paying attention to the intrinsic cryptographic functions used to authenticate blocks, different regulations may be applied depending on countries. As data encryption can be seen as a major security risk for a state, there may be specific regulations limiting the usage of cryptographic algorithms or cryptographic keys. These regulations may affect any data hosted, stored, or transmitted in a country, as well as any data used by any people from this country. Another point to consider is that cryptography is used as the basis of user authentication. A user is simply associated to a cryptographic key. By signing the transaction, it means that the transaction is approved by the entity owning the private key. There is no proved association between this cryptographic-based identity and the real identity. In other words, a transaction can be attached to a cryptographic identity but not to a real identity. It means that human beings or well-known entities can get a private key, but also virtual identity can be generated as if they were a human being and nobody can know it. As a distributed architecture, blockchain regulation is also motivated by accounting and responsibility limits related requirements. Of course, token exchanges are trackable as well as transactions, but the blockchain immutability relies on the consensus mechanism. This leads to co-responsibility of all actors involved in the blockchain, as they share a common asset, the blockchain itself. As threads can focus on different entry points, it means that blockchain systems must comply security requirements as other IT systems. Specific risk analysis to cope with the intrinsic distributed organization on risk must also be developed. Paying attention to the interactions the blockchain has with its environment, we can identify different impact categories that may motivate regulation. First, a blockchain is a distributed system that requires a distributed infrastructure. This physical infrastructure impacts mostly its environment due to the energy it consumes. The IT systems consume energy, the cooling systems also consume energy. As the energy transmission grid is limited capacity, data centers must anticipate their consumption to get appropriate authorization. In other words, a data center cannot grow up if it will lead to a blackout. These limitations must be taken into account while choosing physical location for blockchain nodes and mostly for private blockchains. Second, specific tokens are associated to the different blockchain ecosystems. These tokens may be utility tokens. A utility token is a technical asset allowing to use the blockchain system. But tokens may also be considered as securities, such as cryptocurrencies. Security tokens are de facto unregulated fiat currencies without any counterparts in the real world. developing a new transnational currency impacts the economy and must be regulated as other fund transfer systems. Consequently, different legal constraints must be taken into account depending on the token exist status. As a distributed and poorly interoperable system, blockchain ecosystem governance requires a particular attention. In order to protect the different stakeholders involved in the blockchain ecosystem, regulation may control the way blockchain is governed. In other words, as blockchain are rather closed systems, people investing in blockchain projects must take part in the blockchain decision, and specific regulations may be applied to protect them and their investment. From the early cryptographic techniques to the last blockchain 4.0 technology, we can identify different regulation challenges. First, state security and protection have been introduced from the early cryptographic hashing techniques and the blockchain 1.0. Data encryption may appear as a threat for state security, but the main risk is related to the intrinsic fiat currency developed and owned by the blockchain. This fiat currency is associated to the token. Even if the token is a utility token, as tokens are given as counterparts of the initial fundraising or as payment for block validation. As securities, tokens are associated to fund transfer, and they must comply fund transfer regulation as well as anti-money laundering regulations. Focusing on the blockchain 2.0, we have to pay attention to blockchain-based business development. This challenges to grant a legal status for the blockchain transactions, more specifically for smart contracts. As an IT system, blockchain must also comply rules associated to other IT systems. It must provide action accountability, including logs, transaction tracking, and the system must be consistently protected. The immutability by design, promoted by the multiple replications and the trusted consensus process, may face all threats, but felon stakeholders can corrupt the blockchain, taking advantage of the consensus process to hack the blockchain, steal tokens, and rob blockchain users. This already occurs for the decentralized autonomous organization known as DAO, and it has led members of the ecosystem to decide forking the blockchain just to lose money and restart with a new, not hacked blockchain. The development of blockchain as a service, the integration of the IoT, requires paying attention to personal data protection. As more and more personal data can be used and stored, blockchain systems must comply with personal data regulation, namely the GDPR. We can note that the European Union GDPR serves also as a guideline for other countries to protect personal data of their citizens. As we've just seen, there are several regulation challenges. We present now regulation principles dealing on one hand with the blockchain incentives and core technology, and on the other hand with the token status and the fiat currency development. First of all, regulating blockchain interaction with its environment encompasses both incentives to develop blockchain technology and usages and rules constraining the blockchain system operation and blockchain usages. We can identify different kinds of incentives to support blockchain development. For example, regarding blockchain infrastructure, taxes on energy supply can be used to regulate data centers development, allowing a smooth integration in their environment and supporting their potential development. The establishment of data centers has a strong economic interest in ensuring spatial planning. The development of this activity leads to the development of the associated territory on one hand, because the necessary electricity and data networks are being set up, and on the other hand, because the jobs are created. Second, economic incentives can also be set to support sovereign blockchains, i.e., local development of blockchain systems and products. Of course, this does not fit the universal openness of traditional public blockchains, but setting sovereign blockchain allows securing further business developments by defining precisely the applicable legal framework, providing clear constraints on the location of the physical infrastructure so that data protection can be defined precisely. This can also bring some guarantees regarding blockchain availability. Lastly, regulation can also integrate incentives to promote technology development. Due to its novelty and to the potential usage's novelty, it is not possible to fix a priori a strict regulation perimeter regarding blockchain evolution. Favoring innovation requires evaluating technologies and their usages before adapting or defining rules to regulate these new usages. Sandboxes provide an environment to evaluate technology development and usages, paying attention to the impact it may have on its environment. And after this evaluation phase, rules can be enacted more precisely to control this technology or to consolidate usage. So, as blockchain a legal status, blockchain technology was created in 2009, establishing the first cryptocurrency, the Bitcoin. Then, Ethereum, establishing the first smart contract, was launched in 2015. At fall 2015, the French law Macron II has specified the first legal integration of blockchain technology. In this law dedicated to new economic opportunities, blockchain is considered as an innovative way to record financial transactions, though that the existing rules must be adapted accordingly. Paying attention to business development, smart contracts appear as an efficient way to implement peer-to-peer contracts, leading to recognize these contracts as legal contracts. This leads to establish the first legal framework associated to blockchain, focusing mostly on mini-bonds registration to favor the technology development investments and also on financial applications. Then, in 2017, the Arizona House defines more precisely the blockchain as a distributed ledger, providing theoretically immutable data and providing an uncensored truth. This definition, which has served as a common base for the US federal blockchain regulation, provides constraints on the way blockchain systems are organized. First, cryptography used to protect data must be compliant with the current knowledge to ensure the theoretical data protection. Second, the system must provide an uncensored truth. This means that blockchain must be neutral. It must protect every data in the same way. This constrains blockchain security and blockchain governance. Smart contracts are the main innovation carried out by the blockchain 2.0. Smart contract is defined as an automatically executed transaction. It is often presented as the automated execution of a real-world contract linking parties, defining precisely the contract execution conditions and the contract purpose. Nevertheless, there are some significant differences with traditional contracts. First, as traditional IT transactions, a smart contract implements a peer-to-peer transaction. As such, it cannot be said to implement multi-parties contracts. Second, the process that is automatically executed when the smart contract is filed is a rather simple process that do not require other external inputs than those used to launch the contract. So contracts and smart contracts are quite different. As a legal object, parties approving a contract must be clearly identified. But in a blockchain, people are not clearly identified. The blockchain stores signed smart contracts, but the signature is related to blockchain users, which is not related to a real and trusted physical identity. This leads to a key challenge: how to connect the blockchain pseudo-identity to the proof of the real identity. These challenges have several impacts. First, we have to pay attention to the management of mistaken parties. For real contracts, a mistaken party may be recognized as a valid condition to establish contract nullity. Different countries provide different answers to this problem. While English-speaking countries void automatically the contract, the French law needs extra studies to nullify it. Focusing on smart contract, such nullity due to mistaken party, this requires certifying precisely the parties and certifying that there are no mistaken party before registering the smart contract in the blockchain. Second, parties approving a contract must be capable, namely they must have a contracting capacity. This means that the party identification must be precise enough to know whether this party has the approval capacity. For example, being major, being allowed to represent an organization, and so on. Regarding the smart contract, this involves that the blockchain user must be related clearly to the physical identity and to the necessary information to be accepted as a smart contract validators. To sum up, with its immutable storage, a smart contract defines actions in a code is law approach. This means that a smart contract defines a technical regulation approach, whereas traditional contracts refer to legal regulation and to law organization. This is often described as a code of law. Integrating context and usage and potential consequences into regulation rule is also necessary. As a consequence, smart contract legal status is rather limited to elementary transactions, mostly defining payment conditions. In such cases, smart contracts are created and referenced once the traditional contract has been approved, avoiding by this way the problems related to the parties' identification. Tokens, or digital tokens, used in blockchain ecosystems are digital assets that can be transferred between people. These tokens are sometimes defined as coins. They may have different kinds of value, a usage value or an investment value. Usage value means that a token is associated to a granted right, such as allowing to perform a task to use the system. Usage value allows also the token owner to participate in the system governance. Security value means that a token is associated to a financial value and can be used as a payment or as investment securities. Tokens can be considered either as usage tokens or securities, depending on who owns them and how they are used. To decide whether tokens are securities or not, we can refer to the Owe test. The Owe test has been set by the Supreme Court of the US, SCOTUS, in 1946, while judging Securities and Exchange Commission versus Owe & Co. This test is used to identify what characterizes investment contracts that must comply with the Securities Act. Investment contract is defined as a contract, transaction, or sham whereby a person invests his money in a common enterprise and is led to expect profits solely from the efforts of the promoter or a third party. This means that the investor cannot take part in the common enterprise governance. To sum up, utility tokens can be seen as a tool allowing the owner to use the network. The owner may also take part in the network decision by voting or off-chain governance decision. Security tokens are associated to money investment in a common enterprise, expecting to get profit. They must be regulated as other currencies, of course. Securities are different from commodities, as commodities refer to investment in tangible and day-to-day goods. Payment tokens are defined by financial market authorities as pure cryptocurrencies used to pay for products or services or involved in funds transfers. Depending on the token status, different regulations may apply or not. For example, the initial coin offer associated to the initial fundraising process leads to consider the token as a security token because the initial investors do not participate to the ecosystem governance. These initial investors only bet that the blockchain project they finance will be successful so that their token's value will be increased. A key point for attention is related to the way investors participate in the governance process. A simple approval voting decision is not enough, as the decision is prepared and pre-validated by boards of directors or by systems funders. Such a security qualification was decided by the SEC, the Securities and Exchange Commission from the US, in 2017, when the DAO sold billions of tokens for Ethereum, allowing investors to vote for projects that are pre-selected by boards of directors and funders. So people can define which project they want to finance and get profit from them, but this is still considered as a security because the decision has been prepared by the board. So qualifying a token as a utility, security, or payment token is not so obvious and may depend on the context. So to guide your analysis, we have selected this multi-criteria table used to qualify token. Utility tokens mean that they grant a right, such as product usage or the right to interact with the system governance. They also can be associated to a function. As investments, securities are mostly associated to the expected profit. Securities can be bought or provided as rewards for given work. Lastly, payment tokens are associated to tolls. They represent usage fees or simple security deposit. In such case, this is a deposit without expecting profits. It's just to pay with this representative commodity. This token status guide shows that despite their initial technical value, tokens are considered as crypto assets, so that traditional financial asset regulation should be considered. While defining key regulation principles for virtual assets, we have to pay attention on initial coin offer versus security token offer, ICO versus STO. This leads to identify common regulations principles for crypto assets, paying attention to the context they are used. Initial coin offering are often used by blockchain project holders for fundraising instead of setting a security token offer. To avoid the strict securities regulation, ICO, the initial coin offer, are organized as utility tokens pre-sales. This means that investors do not invest to speculate, but to get the necessary usage tokens, so the crypto commodity, to allow their potential further usage of the blockchain service. But security token offers are regulated out of stocks or bonds offers in order to limit risk for investors. So depending on the ICO characteristics, the quantity of issued tokens, the granted usage rights, the involvement into the governance organization, the financial market authorities may requalify the initial coin offer as a security token offer, requiring to follow the strict stocks bonds approval process. To sum up, for the blockchain project setting, an ICO sounds to be more efficient than the strict registration of an STO. But it requires paying a particular attention to the exact definition of the usage token and to the maybe risky involvement of investors in the shared governance. Of course, for investors, ICOs are not so different from STO, except that an initial coin offer are riskier than security token offer, and that investors may take an important part in the project governance, if there's a real ICO. Another important point to note is that ICO may allow anonymous participation. This refers to money laundering risks and requiring particular regulations to mitigate this risk. This is why regulators often consider and requalify ICO as STO, so that specific regulations, depending on the country, can be applied, limiting risk for investors and preventing fraud. In other words, only security token offer-based fundraisings are totally legal. ICO may be illegal. Another point to consider while identifying regulation principles for virtual assets is the way transactions are defined. Legally, a peer-to-peer transactions require logging traces and well-identified originator and beneficiary. Of course, the immutable storage provided by the blockchain totally fulfills the transaction logging requirement. But the pseudonymous identification of peers related to the private key they own does not comply with the exact identification of originators and beneficiaries, leading to increase the money laundering risks. So, as we've just seen, blockchain regulation mostly refers to the financial side of the induced token economy. In this last part, we will detail the crypto assets regulation motivation, paying a particular attention to the fintech regulation in European Union and in the USA. Let's study first why virtual assets require dedicated regulation. As stated previously, virtual crypto assets are de facto representative commodities. Their value is purely speculative and is not related to any tangible good intrinsic value. We must note that issuing fiat currencies is a sovereign privilege. Each state can decide which currency can be used as payment means for its own economy, and special agreements are set to identify the transaction support currency for international business transactions. Currency is at the core of a state economy operation. The value of the currency is guaranteed by the value of the property held by the state, such as the value of gold held by the central bank. Controlling the economy requires controlling financial flows, managing taxes, and so on. This is why usage of cryptocurrencies is forbidden in some countries, such as China or Egypt. Crypto assets regulation is necessary to mitigate risks. First, it is highly speculative investment, and these investments are very risky for investors. Investment regulation, as those used for securities token offer, mentioned previously, provide control rules on the company issuing the token so that we can ensure that it is a real investment and that reasonable profits can be expected. Uncontrolled virtual assets, such as cryptocurrencies, may have a real impact on the real economy. There are speculative and highly volatile currencies, and they are totally disconnected from the real good value and cost. Using such virtual currencies or crypto assets may lead to important financial uses depending on the way the token value vary. As these currencies are not regulated, there is no way to control their evolution. Financial flows associated to virtual crypto assets are not designed to support full fund transfer travel data. The pseudo-anonymity of the crypto asset owner allows using them as a money laundering system financing criminal and terrorist systems, losing the real identity associated to the fund transfer travel data. This is why the Financial Action Task Force, which gathered international members to regulate financial activities, has proposed a worldwide recommendation to improve the fund transfer regulation and anti-money laundering regulation. The development of new crypto assets requires widening the regulatory perimeter according to different challenges. First, we have to identify clearly these new assets, often used as securities, and the way they are managed. Traditional regulation rules must be adapted to define the ownership on a digital intangible object, as several copies can be made, but also to allow proving the virtual object creation, defining who has the right to create and sell such crypto assets. We also have some regulation territoriality constraints. As crypto assets can be created and exchanged worldwide, we have to define regulation territorial or extraterritorial applicability conditions. Key questions refer to the identification of the competent territory. The traditional users country, infrastructure hosting country, or provider hosting country is more complex due to the worldwide dimension of the Internet supporting these crypto assets enactment. Moreover, defining who should regulate a virtual world requires international agreements to define either universally accepted regulatory principles or a dedicated virtual world regulation authority. We also need a regulation to manage users' or investors' risks. Regulation rules must be set to ensure the consumer information, warning investors about risk and controlling the new retail system by limiting the amounts that can be invested, or checking the retailer's solvency so that risks can be reduced for investors. Let's consider, for example, FTX. FTX fall down as such. Regulation has said that there's no more currency or no sufficient currency to guarantee the company. We have also to pay attention to the money laundering risks and attacks on the real economy due to the pseudonymous identity. This involves that crypto assets must also comply with the traditional transfer of fund regulation. Focusing on the distributed ledger technology, regulation is also needed. First, to protect data stored in the ledger, referring to the GDPR for personal data or to industrial secrecy regulation for company information. We also need regulation to control the way such sensitive firms manage risks, setting resilience constraints to recover in case of attacks, for example, or requiring specific governance organization to identify clear responsibilities and show the awareness of the governance board on risks. A particular attention must be paid on concentration or the competition between actors to be sure that the distributed organization will remain stable. Focusing on a new payment system, regulation is needed to define the new regulatory parameter in order to identify which crypto asset can be used to support payments. We also need regulation to provide the necessary information regarding the cryptocurrency and payment system related to the cost of a transaction, to the warning of the currency speculative risk, or the way the payment system is governed. We also need regulation to control the way payment systems are governed, to manage risk and organize recovery processes to guarantee the payment system availability. Let's now focus on the European Union market in crypto asset regulation, designed to face the important financial risks associated to crypto assets user or to new payment systems such as cryptocurrencies. As these cryptocurrencies are not representative currencies, because they are not government-backed currencies and their value is not associated to goods tangible value. These cryptocurrencies have a purely speculative value. These cryptocurrencies therefore pose a high risk to users as their prices can vary a lot. They are very volatile. Regarding states, these non-governmental currencies can be seen as potential threatening vectors for the real economy, as their unregulated prices variation can impact negatively real economy stakeholders. These are the main reasons explaining why regulating market in crypto assets, called MiCA, is important. This leads the Committee on Economic and Monetary Affairs of the European Parliament to adopt this MiCA regulation on October 10, 2022. This crypto asset market regulation is limited to cryptocurrencies, so non-fungible tokens are not concerned. This regulation deals with all cryptocurrencies. It concerns crypto assets issuers, mostly the most important ones, with more than 10 million users worldwide, to get an authorization to operate in the European Union. This regulation concerns crypto assets issuers because they have to manage stable coins. Their token is a cryptocurrency backed on a stable and real currency to avoid highly speculative tokens. This involves that the crypto asset issuer must keep a liquid reserve and that these tokens can be claimed at any time free of charge. Crypto asset issuers have also to protect consumer wallets. They are responsible of them and must be liable if they lose their investors' crypto assets. To sum up, this MiCA regulation aims at aligning cryptocurrencies market and the traditional banking market, providing the same level of protection for investors and the same control constraints for the token issuers. Of course, the MiCA authorization is also conditioned by the compliance with other European Union regulations such as GDPR or environmental footprint constraints. Let's now focus on another major regulation challenge, the anti-money laundering regulation requirement, avoiding converting illegally obtained money to legal money. The international diffusion of crypto assets, the lack of precise identity control due to the pseudo-anonymity, makes these independent currencies more convenient vectors for money laundering. By this way, tracking illegal activities through the legal currency exchange becomes harder and harder due to the pseudonymous identity used by the crypto asset systems. To improve the money laundering performance, the example picked from the FATF shows that there are multiple crypto assets transactions before converting the crypto asset into a regulated currency, making it harder to identify the real source of the converted crypto asset. Such money laundering organization improves the profitability of illegal activities and have a great negative impact on the real economy. For example, ransomware can lock enterprises' information systems and may lead to bankruptcy, impacting employment and the real economy. Or the illegal money converting also penalize the real economy as taxes are not paid. To sum up, setting efficient anti-money laundering regulation involves setting a universal control on the transfer of funds, providing verified travel information with the fund transfer so that money exchange can be tracked whatever the currencies and transfer of fund systems are. This involves modifying the transfer of fund regulation parameter to integrate crypto asset systems. Fighting against illegal activities and improving the anti-money laundering processes require adapting the worldwide transfer of fund regulation requirements. As shown in the previous example, money laundering systems take advantage of the worldwide deployment of these systems and of the pseudo-anonymity of crypto asset transfer. Crypto assets are not issued and managed by states, but by technological ecosystems. Regulating crypto assets ecosystems to reduce money laundering operation is nevertheless possible by controlling the interface of this ecosystem with the real economy. That is, imposing control on the virtual asset service provider. This is why mitigating this risk leads to set two main regulation requirements. First, fund transfer must be associated to clear and proven identities. This involves defining for each fund transfer, without any exception, even for small amounts, this is the zero threshold regulation rule, the issuer and the beneficiary, and this will provide an end-to-end traceability. It means that transfer operators must manage and log transfers only between issuer and beneficiary with proven identity. It means also that unhosted wallets, which means that wallets not held in custody by a well-identified first party, cannot be accepted as an issuer or beneficiary. Second, the transfer of fund regulation must be set worldwide, allowing an end-to-end control on the financial flows. This refers to the management of territoriality constraints. This needs to identify and control virtual assets provider and to manage chain transactions. We have to be able to integrate intermediary virtual asset service provider achieving the transfer on behalf of another. We have also to ensure that compliance measures are associated for any interaction involving a virtual service provider from a territory where the transfer of fund regulation is set. Similar to the banking ecosystem regulation, the Financial Action Task Force, gathering international board members, proposes to set fintech ecosystem regulation rules extending the perimeter of traditional bank and securities market authorities' perimeter. By this way, compliant and non-compliant virtual asset service providers can be registered, improving the money laundering detection processes. These core transfer of fund regulation requirements involve also paying attention to the way personal data associated to transfer issuers and beneficiaries are collected, stored, processed, and protected. Consequently, the transfer of fund regulation international recommendation from the FATF must be extended by each country to integrate its own personal data protection regulation. For example, in the European Union, this involves that the European Data Protection Board must be involved to define precisely rules, ensuring that the regulation system will fit the GDPR constraints. Fighting against money laundering systems has led the European Union to the development of the transfer of fund regulation. This part of the regulations aims at providing the same payment traceability constraints as those used for legal representative currencies. To sum up, it means that each fund transfer, even supported by a crypto asset, should be associated to a real identity, whatever its value is. This refers to the so-called zero threshold traceability. This involves that the associated fund travel information, which includes the clear identification of the transaction issuer and beneficiary, must be stored with the crypto asset transaction on both sides. This means that the crypto asset service provider, called VASP in the European Union regulation, must collect issuer and beneficiary identification information. Each VASP must log the transaction to fit the double spending proof requirements. As cryptocurrencies are not backed to any representative currencies and can be used worldwide, a main challenge is to manage territoriality or extraterritoriality constraints. It is how this regulation will be deployed, impacting worldwide virtual asset service providers. In fact, this regulation cannot impact directly token issuers, but it necessarily impacts the crypto asset ecosystem by constraining virtual asset service providers operating in the European Union. Existing anti-money laundering directive obliges all companies providing crypto-related services in any European Union member state. It is the company providing crypto asset brokering and trading facilities. So everybody is concerned. Focusing on money laundering facilities, unhosted wallets, so the wallets not held in custody by an identified third party, are impacted by this rule because virtual asset service providers are responsible of collecting and storing information about the identity of the customers involved in the fund transfer. This involves that an intermediary virtual asset service provider operating a transfer for another virtual asset service provider must also be compliant regarding this fund transfer traceability. This leads to make non-European Union entities comply with this regulation. Everybody is concerned. Of course, tracking fund transfers and storing fund transfer travel information involves processing and storing personal information. This means that these information are subject to the European Union GDPR. To this end, the European Data Protection Board is in charge of setting a technical specification to ensure that the transmission of this travel information complies GDPR requirements. By integrating an end-to-end traceability to crypto assets transfer, this transfer of fund regulation aims at stopping illegal flows in Europe, increasing virtual asset providers' responsibility in the anti-money laundering process. Let's now consider the way USA regulates the crypto assets ecosystems. As in the European Union, crypto assets were first regulated under the free market regulation. This regulation strategy states that only useful and fair technologies will be used and supported so that they can be developed. Nevertheless, as in the European Union, USA considers the financial and economic risks leading to integrate the FATF standards by extending the Bank Secrecy Act to integrate digital assets in the scope of this regulation. The key differences with the European Union are the integration of NFT as investments based on NFT in the metaverse can take part in money laundering systems. There are also reduced personal information protections as there are no specific personal data protection in the USA. By developing digital assets regulation, USA aims at facing potential financial stability harm and increasing national security, avoiding money laundering systems related to terrorism and other criminal activities. Similar to the European Union, the US regulation fits the FATF's challenges to support a responsible development for virtual assets, avoiding the jungle law-based development of highly speculative systems. This leads to regulate fund transfer by integrating travel information, namely the issuer and beneficiary well-identified and checked identity in the transfer transaction. They will also regulate digital securities in a similar way as traditional securities. This enforces the link between virtual assets and the real world. Representative currencies and protecting investor and virtual asset deposits are also targeted by this regulation. So, after introducing the regulation context, defining blockchain regulation key principles, and paying particular attention to virtual assets regulation, it's now time to conclude. Blockchain regulation aims at defining a legal status of this technology and regulate its related usages. In this lecture, we introduce the regulation context, identify the legal definition of blockchain, and address the legal status of tokens and smart contracts. In this presentation, we can see that these legal status and key regulation principles are similar to those regulating contracts and securities. In the real world, as the blockchain technology is used as a major drive for fintech development, we paid particular attention to the virtual asset regulation. Even if regulation is set by each country, we have seen that common regulation principles have been set by the FATF, leading to similar regulations and worldwide applications. By controlling the way digital assets ecosystems interact with the real economic world, fund transfer and market crypto asset regulations are set to support a responsible digital assets development. Further regulation constraints related to GDPR and personal data protection in blockchain environment will be discussed in Lecture 6. You can find in the following resources extra information or legal text regarding blockchain. Each internet link has been tested by the fall 2022. Thanks for attending this CHAISE Module 2 lecture about blockchain regulation. We can get in touch using social media, website, and so on.